Hello and welcome back to NF Tuesday, where I do a deep dive into NFT projects. But this week, of course, we're going to talk about the FTX collapse. From a legal perspective, I'm going to walk you through some of the issues I spot as a lawyer, just to kind of shine some light on some things. I think you'll find it interesting. But real quick, let's talk about how we got here. FTX is this giant trading platform. They've really sprung on the scene in the last 2 years, raised a shit ton of money. They really got their name out there with marketing and branding. The Miami Heat basketball arena was renamed FTX Arena. If you watch any of the World Series, the umpires' jerseys had FTX as a sponsor. Cal Bears football renamed their field FTX Field as well. So they really got their name out there, and they're becoming a giant in the industry, advertising on the Super Bowl. Tom Brady was a big investor and founder. So really big names attached to it, and they were really, really widely known. And they were trying to get as many customers, obviously, as possible to really grow and get a stranglehold on the industry. And everything kind of collapsed like right away. Like, it's amazing how fast things happen, especially in the crypto industry. And it kind of reminds me of Enron like 20 years ago. Enron was this giant energy company that came out of nowhere. The Houston Astros renamed their field Enron Field, and then it turns out that there was a bunch of fraudulent activity going on, and it came down so freaking fast. It also reminds me of the company Theranos, the Bay Area healthcare company that was founded by a young, charismatic leader, Elizabeth Holmes, not dissimilar to the owner of FTX, Sam Bankman-Fried, a young, charismatic guy with a giant idea to create a monster, website that will be able to trade anything. You'll be able to trade gold, securities, commodities, cryptos, everything. That was his vision for FTX. And Elizabeth Holmes' idea for Theranos was to be able to take a single drop of blood and be able to test for like 300 different diseases and conditions. And as it turns out, you can't do that, and it was all propped up by just this mystery and wonder about this person and their grandiose idea. And once you actually looked under the hood, first glimpse you get a look under the hood, it's like, oh, there's a shit here. This is a complete house of cards, and those things come down really fast. That's what happened here. So, like, how did we get here? Well, okay, so FTX is owned by Sam Bankman-Fried. FTX is below. They had a sister company, Alameda Research, okay? And it turns out the token that FTX created basically as like a placeholder for money so that the rest of their assets could be more easily interchanged. It turns out that once customers started to withdraw money, there wasn't enough to go around. Now, typically this isn't a problem. Like if I go to my bank in the States, whether it's Chase, Bank of America, Wells Fargo, whatever, and you try to withdraw money and the bank says, oh, sorry, we don't have enough to cover it, you're fine, because the federal government requires that you're FDIC insured. So if you've ever gone to a bank in the US, you might have seen this logo. So this logo is the FDIC logo. That stands for Federal Deposit Insurance Corporation. You said it was created in 1933. This is after the big stock market crash, and this is written into law. So if you want to have a bank in the States, you have to comply with these regulations. It says, here's the Federal Deposit Insurance Corporation, regulations and statements of general policy. And if we go down here real quick, just to show you what the fine print says, standard maximum deposit insurance amount means $250,000 adjusted, yada, yada, yada. So the point here is that in standard banking, if there isn't enough money for the bank to pay out, the federal government says, we've got your back. We want you to be able to trust us banks. We don't want this to happen again, like in the stock market crash in 1932, 1933. We need to find a solution for this, and the way we're going to do it is we're going to require every single bank to have insurance, to purchase insurance from us to backstop in the case that there isn't enough money to pay out customers. FTX is not a United States bank. They're a company formed in Bahamas, and they don't have to comply with banking regulations for that reason. Now, this is very ironic because the big claims that everybody who's into crypto makes is we don't want to trust banks. banks get these bailouts. That was kind of like the premise or like the triggering thing for Bitcoin. At the very first block of Bitcoin, there was a note in there about a bank bailout. And they said that this is stupid. We don't need these intermediaries anymore. Why do we have to trust them if they're going to, really kind of work in cahoots with each other, et cetera, and to help each other out in a way that hurts the consumers. We need a solution to this, and it's going to be this completely deregulated technology called blockchain, and that will put all of the responsibility back in the banking customer, which is a good idea until it's not. In this case, it wasn't the technology that failed FTX. It was the person at the top and the people running the finances that let everybody down. We'll get into that a little bit more. But really the problem here was the individuals committing the fraud and not the technology itself. And because FTX is not a United States bank, they're not recognized by the United States as a securities trading company, they were under the purview of all this regulation. They never had to purchase FDIC insurance to backstop all their customers. And then once they started withdrawing money and there wasn't enough to go around, there wasn't anybody like the U.S. government to back them up. So it's very ironic that all this deregulation that the crypto folks wanted has come back to bite them in this instance, when turns out, yeah, you are trusting somebody when you're dealing with any exchange. I love the phrase, not my keys, not your coins, right? If you're ultimately trusting somebody else, whether it's Coinbase, Binance, FTX, or whatever, like this trustless system has evaporated because people don't understand the concept of having to store your keys and everything in a cold wallet that's unreachable by anybody else. So in this sense, when FTX started going under, and they were trusting all along that the balance sheet of, not even the balance sheet because they couldn't see it, they're trusting all along that, look at FTX, they're everywhere, they got all this money, they're renaming basketball arenas and sponsoring umpire jerseys, of course they have money to pay everything out. Nope, not the case. You trusted something that you shouldn't have trusted. This young, charismatic leader with a grandiose idea turns out to probably be a crazy narcissist. And if you look at some of the statements he made publicly on Twitter and even in front of the Senate, I think it was the Senate, in his interviews, like he's literally condemning crypto companies from doing exactly what FTX ended up doing, which is, it's just bananas how just clear cut a lot of this is. And in a few minutes, I'm going to show you exactly how that will be used against him. But first, how did we get here, right? So we know that the customers started to withdraw money. Why did they start doing this all of a sudden? Well, let's take a look at this article that Coinbase wrote. So here's an article that was written November 2nd, 2022, so just under 2 weeks ago, saying divisions in Sam Bankman-Fried's crypto empire blur on his trading titan Alameda's balance sheet. Alameda was a sister company to FTX. It says that Alameda had 14.6 billion of assets as of June 30th. And this is what gets my ears to perk up as a lawyer. According to a private document CoinDesk reviewed. And then much of it is the FTT token issued by FTX, which basically means that it's FTT token basically means it was money printed out of thin air. It was done in good faith initially for a purpose of being able to facilitate trades. It was basically kind of their way of insurance, kind of like their own insurance. They're like, well, if we ever are a little short, we'll just pay out some of this FTT token. Nobody will ever come calling for it and we'll be fine. Well, they did end up trying to redeem all that FTT token for actual money, and that's when the house of cards fell apart. But again, the key, that thing that I hear as a lawyer here is according to a private document CoinDesk reviewed. Okay, so to me this means somebody breached their NDA. Somebody breached their non-disclosure agreement, okay? And usually my opinion is NDAs are kind of bullshit. Honestly, I think they were created by lawyers so we could bill more hours and charge more money, but we kind of have to do them so that there's a written understanding between people that we can rely upon in instances of a breach just like this. So in every NDA ever written in the history of the world, there's a clause that says, here's what's actually confidential. Here's what's actually confidential information. It'll say a million things. Okay, it's very broad. Say documents, plans, protocols, procedures, processes, and usually you want to be a little more specific, but that's not what I'm worried about. After the confidential information is defined, there's always an exception that says, here's what confidential information isn't, just in case you were curious. And that's an interesting part here, because here, like, how did CoinDesk get this document? How did they get this document? Well, they had to have known somebody on the inside at FTX, okay, or Alameda. It had to have been somebody with visibility of their balance sheet. So it had to be somebody really high up at, in like the finance arm of the business, or maybe one of their accountants, or maybe somebody at some bank somewhere that had a reason to see it. Maybe FTX had to open a bank account and show a profit and loss statement, and this was kind of leaked over to CoinDesk. I don't know. I don't know if we'll ever know, but it's possible that it could be subpoenaed during the course of litigation. But that might not even, that person who did share the document might not have actually breached their NDA, and I'm going to show you why. So this is a pretty standard exception clause to confidential information. So let's read through it real quick. Confidential information shall not include any information that A, is developed by a party without use of confidential information as evidenced by written records. What does this mean? That means that if you come up with it yourself, then it's not confidential, okay? If it was rightfully obtained without restriction from a party, from a third party, that means that it wasn't confidential. If I got it from somebody else, it clearly wasn't confidential between the two of us, so we're not going to count that as confidential information either. C, information which was already known to a party at the time of receipt from the disclosing party. Again, you can't tell me it's confidential if it's something I already knew. Information that is publicly available in a form readily known or readily ascertainable by a party other than through the fault or negligence of the disclosing party. Again, it's not confidential if it's public. Or D, information that must be disclosed pursuant to any government statute, regulation, or any court order, provided that a party takes reasonable actions to avoid such disclosure, including, if possible, providing prompt advance notice of the impending disclosure to enable the disclosing party to seek a protective order, otherwise prevent such disclosure. And then F, quickly, it's not confidential information if the information was known to a party at the time of its disclosure with the full right to disclose prior to its receipt, as evidenced by written records. Again, basically, if you already knew it and we already had the right to disclose it, then you can't tell me that it's suddenly confidential information. But the part I want to rely on here is that it must, if the information must be disclosed pursuant to any government statute or regulation, then it's not confidential information, and therefore the terms of the NDA wouldn't apply to that person. And again, this exception, more or less, maybe some words are changed, but this exception is in every NDA everywhere. So if this person who's high up at CoinDesk, at FTX, who had visibility, or Alameda, who had visibility of these profit and loss statements, if that was disclosed pursuant to a regulation, like in the States, if you are an auditor or a banker and you become aware of fraudulent activity, you have to report it, okay? So I'm guessing that that is, at least that would be the best clause, type of clause you would rely on if you were that person. Now, how are we going to find out who that person is? How are we going to do that? Well, what would probably happen, here's kind of how litigation works. Sam Bankman-Fried will be pursued criminally by attorneys general, and SEC prosecutors, etc., in the States. And during the course of that criminal prosecution, he'll be subpoenaed for a bunch of information. And in response, Sam Bankman-Fried gets to make his defense too. Okay, we're going to assume that he is summoned to the United States because a lot of people in the United States were affected there. They advertised to United States customers on, in Super Bowl ads and jerseys and naming rights and everything like that. So they certainly made themselves available and availed themselves under United States laws, as we would say, lawyers would say. And there's going to be a bunch of fighting back and forth about what documents are allowed and aren't allowed, and which ones you have to share and which ones you don't have to share. What would probably happen is in the course of creating a defense for Sam Bankman-Fried, they would subpoena CoinDesk and say, how the fuck did you get this document? Who was it? Tell me when you got it, where they got it, and they would attack it from there. So I'm guessing that it'll be known at some point what the identity of the person who leaked the document was, and they will then be able to determine, okay, was this person in breach of the NDA or not? It's not going to fucking matter. I mean, the cat's out of the bag, and this person, I don't think in any jurisdiction would be held liable for a breach. And I'll explain a reason for that also later, something called in pari delicto, which is a Latin term meaning the court will leave parties where it finds them. So if you're committing a shit ton of fraud and your employee breaches a contract that he signed with you, the court isn't going to help you. What are they going to say? Yeah, the employee or the banker was obligated to continue to keep his mouth shut so you could continue on your course of fraud. No, that's not how it works. The court would say, we're not going to hold this person who leaked the information to CoinDesk liable because we're going to leave the parties where we found them, right? So that's the reason why this exception to an NDA really isn't going to cause any trouble in my estimation. And then the last thing I want to get into about the FTX collapse and the pursuit of Sam Bankman-Fried for civil damages, right, to get some of your money back, might not even be necessary because presumably the criminal charges will order restitution, meaning that he'd have to pay back money to all of the people that he defrauded. But like, what happens? Like, how does that happen? Like, what do you mean? Like, okay, you're going to charge him or you're going to sue him, which means you have to serve him with a lawsuit, like in the movies, right? Like you got served, right? And then what? Okay, well then this defense starts and they share documents, they argue about what they have to share back and forth, okay? And then what? Okay, then maybe you go to trial. I mean, I think he'd probably settle, but you go to trial. Let me start this over. And then the last thing I want to look at, because I don't think anybody's really familiar with this, like your layman isn't going to know that, like where the fine print actually lies when you're trying to prove that somebody committed fraud or intentional misrepresentation or negligent omission of facts, et cetera, et cetera. Like what is that actually, like what do you mean? Like how do you actually prove it? Like imagine you're in the courtroom, you're a juror, okay, you're a juror, and you're watching this trial happen, and you're going, okay. All right, seems like some shady shit happened. All right, so now what? And what they'll do is they'll give you jury instructions. They're going to instruct the jury, and there's cases that go up to appellate courts and Supreme Courts about this, fighting about whether the instructions given to the jury to help them make their decision were fair or not, okay? And this is something that attorneys will look up when you're thinking about bringing a charge against somebody. Sure, you're going to look at the fine print in the law and the code, and usually the jury instructions are somewhat of a mirror of that, but every state has fine print written out there about the jury instructions of what actually has to be said and delivered to the jury to help them aid their decisions. And this is what you want to look up if you're ever curious, like, okay, is this person going to go down for this crime or this civil claim against them for money? So this will help you key into like, okay, what can they actually prove and what are the jurors actually going to hear? Because that's really where everything kind of comes to a head, is what would a juror decide? That helps with your leverage in terms of your understanding of like how you can negotiate about this. If you don't think the jurors are inclined to agree with your case against somebody, then you probably can't eke out quite a good settlement. But if the jurors are going to be on your side, and if you know that the instructions given to the jurors are clear and based on the information and the evidence you'll be able to put forward, you think that they will be able to determine that, yeah, this is fraud, then that helps your leverage. Of course, at trial, trial, right? It's going to help you at trial by, matter of fact, but also in the pre-settlement negotiations, because you're going to be able to say, well, yeah, listen, this is what I got to prove to this guy. And look how easy this evidence made me. It makes it for me. So let me show you just real quick a couple of the jury instructions in New York. I'm going to choose New York because usually big like white collar fraud claims are brought in the Southern District of New York. That's kind of where Wall Street is, right? So that's where all these cases are brought. So in New York, they call them the New York pattern jury instructions. Intentional torts, that means like negligence or like in something you did intentionally, intentional damage. So here we go. Let's look at fraud. In order to recover for fraud, AB, that's going to be the plaintiff, okay? They're just using A, B, C, D as just placeholder names, kind of like an FTT token. Haha. In order to recover for fraud, the plaintiff must prove by clear and convincing evidence that CD, that's Sam Bankman-Fried, made a statement of material fact. That means material fact means an important one. If he said, I went to Wendy's last night for dinner and it turns out he went to Arby's, that doesn't matter. We don't fucking care about that. It's like, is it something important that you relied upon? And there are further jury instructions just about what material means, but we won't get into that. I'm just showing you that like where this stuff actually lies. CD made a statement of material fact. The statement was false. Okay. This is important too. You might think that's simple, but what if it's a matter of opinion? Okay. That's like a defamation cases often rest on that, whether it was a false statement or whether it was a matter of opinion, right? And that's back here too with fact, right? Was it fact or was it opinion? That defendant, Sam Bankman-Fried, either knew that the statement was false or made the statement recklessly without regard to whether it was true or false. Well, what does that mean? Well, obviously if Bankman-Fried knew that there wasn't enough money to cover his assets, to cover customer withdrawals, then that's a knowing misrepresentation of fact, assuming he made one. We can look at tweets and statements he made publicly and on Twitter and stuff to support that. But let's say he just like, you know what? Looking at our financials, it can only hurt me. I'd rather like be an ostrich style and just bury my head in the sand. That way I'll never know. Well, you can't get away with that either. You cannot recklessly, without regard, make a statement without caring about whether it's true or false. So you can't guess, right? Also so to continue, Bankman-Fried made the statement to convince AB to rely upon it. So something publicly like, we have a bunch of money in our bank accounts. So something like this would be a good example. We're trying to prove that he made the statement to convince the plaintiff to rely upon it. And here he is. This is 5 days after the CoinDesk article that he says, FTX has enough money to cover all client holdings. We don't invest client assets. We have been processing all withdrawals and will continue to be blah, 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 withdrawal seat. But listen to that first statement. FTX has enough to cover all client holdings. That's something you say to customers to keep them in the game, to make them not panic. Okay? And whether you make that statement and it's false or you're accidentally wrong about it, if you're the leader of the company, then that's a reckless statement to make and you're going to go down for it. All right? So he made the statement for the purpose of convincing AB customers to rely upon it, that the customers did rely on his statement, and then their reliance on the statement was justifiable. I won't go into the details there, but there are circumstances where it's not really justifiable to rely on somebody, and that the customer sustained damage because they relied on the statement. Okay, so that's an example of fraud. Okay, so that's what you have to actually show. The trial attorney has to show to jurors to get them to agree that somebody committed fraud. And the instructions will be a little bit different in the criminal court, but still pretty similar. Let's look at one more. Okay, so these are the jury instructions for negligent misrepresentation. It'll be fairly similar. Let's dig in here. So to recover, the plaintiff has to prove by preponderance of the evidence. That's a very different standard. It's a very different standard than clear and convincing evidence for fraud. Okay. Preponderance means more than half. Clear and convincing is like pretty close to like 90, 95, 100%. That's a very different standard, much more difficult to prove fraud. So they have the burden of proving by preponderance of the evidence that Bankman-Fried stated, and then you list the statements that were made, that the statement was incorrect, that Bankman-Fried failed to use reasonable care to ensure that the statement was correct, just like that tweet I just showed you where he's saying days after the CoinDesk article and days before they filed for bankruptcy that they'll have enough money to process customer withdrawals. That is a failure to use reasonable care to make sure that that statement was correct, that the plaintiff heard the statement and that they knew, or a reasonable person in their position would have known that they would rely on it, and that they did rely on it, that their reliance on the statement was reasonable. This is pretty much more or less the same thing as justifiable. And as a result, they suffered damage. Okay. So again, this is just showing you that if you actually go to the courtroom and you're going after somebody for breach of contract, for a car accident, that's just standard negligence, or for fraud like this, then you have to, it boils down to what are the jury instructions. And the jury instructions usually mirror exactly what the law says, but cases will go back and forth, sometimes up to appellate courts and then back down for a retrial and stuff because jury instructions are unfair or misleading. So this is just kind of a deep dive. I know it's not super crypto related, it's not really NFT related, but it shows you like from a lawyer's brain, like where my brain goes when I read about this stuff. And I'm just trying to show you, like, if you always ask, okay, what actually happens there? Like, how do you actually prove somebody committed fraud? Where do you actually get the information? What defenses do they have? And like, what did the jurors actually hear? Like, how is that decision actually made? How is that decision informed? This is the type of stuff that you look at. Okay. So anytime you hear about, a website or a publication receiving a confidential document, that means that an NDA was probably breached, but there are exceptions in NDAs. And there are jury instructions that show exactly what you have to prove to inform jurors, or sorry, what you have to inform jurors of to lead them to their decision. So stay tuned, watch my Fine Print Friday video, in which I'll look at how the Miami Heat arena can probably yoink the FTX name off them. Same thing with Major League Baseball umpires, Cal Bears football also. And next week, I'll try to do a deep dive into the terms and conditions of the FTX customer agreement. It's like 62 pages long, which is longer than most, but that's common when you're doing any type of trading platform, whether domestic or abroad. So thanks for watching. Stay tuned. Hold on for dear life, everybody, and see you next time.